Hello everyone, today I will be speaking on the subject of reassessment. Now why reassessment is because of the increasing litigation on the issues of reassessment, and also a major number of the writ petitions in the Bombay High Court filed contain the issues with respect to reassessment. And hence a small initiative has been taken by itatonline.org and KSA Legal Chambers so that the tax practitioners are benefited and they may make better representations, and this video may be helpful for them. Today I would be speaking on the small part of reassessment, that is, what are the steps to be taken the moment a notice under section 148 is issued or served on the SSE. What are the steps? Before knowing what are the steps, let's move on to understanding why a notice under section 148 may be issued or may be served on the SSE. Firstly, three components have to be fulfilled, after which the AO may serve, the assessing officer may serve a notice under section 148. Firstly, the assessing officer must have a reason to believe that there is escapement of income based on some new tangible material. There has to be a reason to believe. Such reason should be based on some new tangible material, and the belief of the assessing officer should be based on such new tangible material is that there is escapement of income. Once these three components are fulfilled, are complied with, then the AO may serve a notice under section 148 if he is satisfied. Now, the moment the notice is received by the SSE, such notice under section 148, then what are the steps to be taken? This has not been mentioned anywhere in the Act specifically, but the Supreme Court has come into rescue and mentioned the guidelines or stated the procedure that what are the steps to be taken in the case of GK and drive shafts. It is mentioned that the moment a notice under section 148 is received, the SSE must file his or her return of income in response to the notice under section 148. However, we also see the general practice that a letter is also filed stating that the return of income already filed under section 139 may be treated as a return of income to be filed in response to the notice under section 148. However, recently there was information that a few SSEs had received some prosecution notices with respect to non-filing of return of income and only giving mere letter. Now we have a Rajasthan High Court which states that even a letter can be filed, a letter stating that the return of income already filed under section 139 may be treated as a return of income to be filed in response to the notice under section 148. But however, it is advisable that the SSE signs such letter and not the authorized representative of the SSE who signs such a letter in response to the notice under section 148. Now, the moment the SSE files the return of income, he also has the option of asking for the recorded reasons. Now, such recorded reasons, the SSE only has an option. He may not ask or he may ask, but however, it is advisable that the SSE ask for the recorded reasons. Now, once the recorded reasons are asked for, the SSE will have to provide such recorded reasons within a reasonable time, is what is mentioned in GK and drive shafts by the Supreme Court. But giving more clarity, the Gujarat High Court has brought in further details after taking into consideration GK and drive shafts of the Supreme Court, giving further details as to how many exact number of days is also provided by the Gujarat High Court. The Gujarat High Court mentions that within a period of 30 days, the assessing officer will have to provide the recorded reasons to the SSE within a period of 30 days. Now, once these recorded reasons are provided to the SSE will now have to raise objections against these recorded reasons within a period of 60 days. Within a period of 60 days from the date of receipt of the recorded reasons, the SSE will have to raise objections against such reasons recorded. Now, the moment the assessing officer receives such objections within the specified time limit, the assessing officer is bound to dispose of such objections within a period of 4 months. within a period of 4 months. And uh, such objections have to be disposed of by a speaking order, which has also been mentioned by the Bombay High Court recently. So hence, within a period of 4 months, such objections needs to be disposed of, and such disposal should be by way of a speaking order. Now, the moment such objections are disposed of, can the assessing officer directly pass the reassessment order or the assessment order, or would he have to wait? Now, the Bombay High Court in the case of Asian Paints has mentioned that a minimum period of 4 weeks has to be given from the date of disposal of objections and the date of passing of the order or the initiation of the reassessment proceedings. These are the basic few steps, and however, recently a Delhi High Court has laid down further guidelines even after all the already mentioned case laws. And such guidelines should be adhered to by the revenue authorities, is what is mentioned in the judgment. The judgment says that the moment the recorded reasons are asked for by the SSE, the the assessing officer must provide the recorded reasons along with the standard form in which the appropriate sanction has been taken from the appropriate authority. Now, the standard format generally has the conclusions or the comments of the superior officer, and also the name and designation, etc., which means the assessing officer cannot merely write a simple letter stating that the sanction has been taken from the superior authority and give it to the SSE. That is the first step or the first guideline that the revenue authorities will have to follow. The second guideline is that such reasons have to be very specific, and all of such reasons have to be mentioned which are provided to the SSE. And in case such reasons are based on some investigation report, etc., then the details of such investigation report has also to be paraphrased and given to the SSE, and also any inquiry done by the AO or the assessing officer soon after such investigation report and any conclusions thereof also have to be provided to the SSE by the assessing officer. Now, that is the second guideline that is to be followed. Now, the third guideline, which is also mentioned in the Delhi High Court judgment, is that in case such reasons are based on some kind of a document or a report, then such document or the important aspects of such report should also be enclosed along with the reasons provided to the SSE. And once objections are raised against all such reasons provided, the assessing officer will have to dispose of each and every objection raised properly and give appropriate reasoning for each and every objection, since it is a quasi-judicial activity that is being done by the assessing officer and they cannot take it lightly. Now, these are the few steps that are to be followed. So now we will go ahead with making a small checklist as to what are to be done. So the first step that is to be taken is, the moment the notice under section 148 is received, check what is the date on the notice, whether such a notice under section 148 is being served on the SSE beyond a limit of 4 years or within 4 years from the date of the assessment year under consideration. Now, the moment we check the date, also check whether the appropriate sanction has been taken from the appropriate authority. Now, why I say this is because in case the reopening is being done within a period of 4 years, then the assessing officer, if he is below the rank of JCIT, Joint Commissioner of Income Tax, then they have then the permission of the JCIT has to be taken. The permission of the Joint Commissioner of Income Tax has to be taken. The moment the reopening is beyond 4 years, then the sanction has to be taken from the Principal Chief Commissioner of Income Tax, or the Chief Commissioner of Income Tax, or the Principal Commissioner of Income Tax, or the Commissioner of Income Tax. And hence we have to look at the date and also the appropriate approval, whether it has been taken or not. Now, the second phase would be in the checklist, that once the reasons recorded are received, check what is the date of the reasons recorded, because the date of recorded reasons cannot be subsequent to the notice that has been issued under section 148 as specified under section 148 subsection 2, that the reasons should be recorded prior to the issue of notice under section 148. Also check whether it is beyond 4 years or below 4 years. Check whether appropriate sanction has been taken, and also check whether it is a mere change of opinion in case the original assessment was done under section 143.3, that is scrutiny assessment, and all the details had already been provided. Then also check whether the same material is the basis for the reopening. Then it would constitute to be a mere change of opinion, which would be bad in law. Next, also check what are the reasons recorded. Check each and every reason, and also check whether that a mere gist of the reasons or mere a small copy of the reasons, or whether detailed list of every single reason recorded is being provided to the SSE. In case any further details which are only available with the AO, that is the sanction taken from the appropriate authority, or maybe the information based on which the AO relies upon to reopen the case, then the SSE must file an application under RTI, that is Right to Information Act, and extract such details as are required, and finally raise detailed objections in response to all the reasons recorded. Now the moment all such objections are disposed of, then the SSE's next job is to see whether he has to approach the High Court in such cases, and also check whether the reassessment proceedings have started within a period of 4 weeks from the date of disposal of the objections raised by the SSE. These are the few steps that are to be followed the moment the SSE is in receipt of the notice under section 148. Also, a few more points I would like to mention, that in case the service of notice is on the authorized representative and not the SSE directly, such service of notice will be invalid, which is stated by the Lucknow Tribunal. And also, in case the service of notice is on the wrong address of the SSE, then also such service will be constituted to be invalid, stated by the Delhi High Court. And in case the approval given is done in a mechanical manner, assuming that a mere yes is stated and signed, so such an approval will be invalid, stated by the Supreme Court. Then also, in case approval is taken from the wrong authority, even then such a reassessment will be void, which is stated by the Bombay High Court. These are the few points, and for any further information on reassessment, kindly visit itatonline.org, wherein various articles will be available written by various authors, and which would be very useful for all the viewers. And in the next video, I would be coming out on what are the steps to be taken in the course of reassessment proceedings starting soon after the disposal of objections raised. Thank you everyone. Hope this has been a very informative video.